by two brilliant speakers. Oh, that's the sign that's being live streamed. We have Karen O'Sullivan from Advice for Renters, and we have Peter Habott from the Property Ombudsman, and they're going to be going over some really, really important stuff and everything you need to know about what landlords and letting agents' roles and responsibilities are towards you. So I believe we'll be kicking off without further ado with Karen and her presentation. So I'll stop sharing my little cover screen.
So hello, I'll just get my slides up, shall I? So I need to share my screen and then I'll expand it.
Excellent. Over to you.
It worked?
Yes, over to you.
Okay, so hello, I'm Karen O'Sullivan, it says there, from Advice for Renters, and yeah, we're basically like a law centre, but we only do housing law. And I mentioned earlier, my colleague Mark, who's a solicitor, is also here. So at the end, if you've got any questions, you can ask me or you can ask Mark. One of us will be able to answer. Right, so we'll I'll get on with the slides. The presentation is about responsibilities of landlords and letting agents. So what they have to do before or sort of during the duration of a tenancy, and at the end, I suppose. So moving on to the first slide, I just wanted to specify that the presentation is basically relevant to private rented sector assured short-hold tenancies. So that's a mouthful, but you probably have one of those if you're paying rent, you've got exclusive occupation of your property, whether that's a single room or a whole flat or a house, and you don't share with your landlord. So they're the most common types of tenancies. But this presentation might not apply to you if you're a lodger sharing kitchen and bathroom with your landlord, that kind of thing. And so one of the first things the landlord has to do, or either the landlord or their letting agent, is that they must check that a prospective tenant has a right to rent. And that's really their responsibility. It's not really beneficial or otherwise to the person renting. But it does tie in with my next slide. This is why I've got a whole slide on it. But basically, you will be able to rent in the UK as long as you can live, as you have a right to live in the UK. So they'll want to see your passport or whatever other immigration document you've got before they rent. Otherwise, they can get in trouble. And so that is mentioned in this slide about the holding deposits. So since the Tenant Fees Act 2019, I think that came into force in 2020 though, landlords or letting agents aren't allowed to charge these random fees. There are only certain things that certain permitted payments that a landlord can ask a tenant to pay. I've focused here on the holding deposit. So sometimes a letting agent might ask you to pay them a deposit if you want them to kind of keep the property, a tenancy for you, while they do their checks and not rent the property to anybody else. So if they do that, they can charge maximum a week's rent for a holding deposit, and they have to give it back unless you fail a right to rent check, or if you change your mind through no fault of the landlord, or if you give false or misleading information. So other than that, if you pay a tenancy holding deposit, it has to be paid back to you. And even if these things happen where you wouldn't, the landlord wouldn't have to pay it back to you, they still have to give you notice that they're not going to pay it back. If you're not given notice, they still have to pay it back. And then, if you're curious about other tenancy fees which are permitted, maybe you can ask us later at the Q&A. Another responsibility of your landlord is to give you certain tenancy documents at the start of the tenancy. So it's the gas safety certificate, energy performance certificate, how to rent checklist. And it's not just about giving you the piece of paper. If they've given you the piece of paper, it means they've done these checks. It means the property, its gas supply is safe. The energy performance certificate is to do with how energy efficient the property is. So if you've got a very low efficiency, obviously you want to know, because you're going to pay more in heating costs. Your property might be colder than you want it to be, and it's rated from A to G, and the lowest it can be for a property to be able to be rented out is E. So if you've got an F or a G, then that landlord shouldn't be renting out that property. And then the how to rent checklist gives you your rights as a tenant. It's it's a really good resource. If you go through that, it's really tells you everything you need to know as a tenant, all your legal rights. Sorry, that's my dog in the background, Louis. Anyway, so it's really a good resource. Now, if you'll notice the word current there, because they get updated. So you should have the most recent one. So there are circumstances where your landlord doesn't have to give you the most recent one, as long as it's giving you the one in force when you started your tenancy. But generally, you should be given the up-to-date one. And if they don't do all these things, then they may not be able to evict you if it comes to it. So tenancy deposit. My colleague Mark, who I mentioned, is really good with tenancy deposits, in that there are certain circumstances where if a landlord or a letting agent has breached the tenancy deposit rules, then you could be entitled to compensation. And that's what one of the things that Mark does, because to get that compensation, there's no legal aid available. I don't think you get your costs back, even if you pay a lawyer and you win the case. I don't think you can get your legal costs back, but Mark can correct me if that's not the case. So the tenancy deposit cannot be more than 5 weeks worth of rent. It has to be protected in an authorized scheme. So within 30 days of you paying your landlord or the letting agent your deposit, they've got to put it in a scheme. And also they've got to give you information about the scheme, the circumstances in which your deposit can be withheld at the end of the tenancy, and lots of other information. And if they don't do that, they may not be able to evict you, and you could be entitled to compensation. And of course, they can't, at the end of the tenancy, the deposit has got to be paid back to you, because, unless there's a good reason why the landlord should keep it. And it should be explained in your tenancy agreement what those circumstances are. Licensing is another responsibility. So not all properties need to be licensed, but certainly houses in multiple occupation need to be licensed. And I don't know how much time we've got to get into the detail, but if you're sharing with, I think it's 5 people, and you're sharing bathroom and kitchen facilities, or at least 2 people are, then the landlord will need a license for that. And and the license also means that the landlord has to do, or the license requirement also means the landlord has to show the local authority, the council, that they've complied with the various requirements to have an HMO, house in multiple occupation. There are some councils that will require a license for smaller HMOs, and then selective licensing. Some councils require a license even for a sort of a normal tenancy, of not, just one household, not sharing with anybody. And to find out if you're in one of those properties, then you can go to your local council's website. Normally there's a map of the areas where selective licensing applies. And again, if the landlord doesn't license a property that should be licensed, then they'll be in trouble. They could be prevented from evicting you. They could get banned from renting, and they could be made to pay back some of the rent. And again, that's a rent repayment order that that you could get from a tribunal. If your rent is paid by universal credit, then you can't get that. The council has to apply for that. So it's a punishment for the landlord, but you won't get your rent back. And then the landlord or the letting agent, depending on who's managing the property, has got to make sure, but ultimately it's the landlord's responsibility. It's got to make sure that the property is safe and free from disrepair. So safe, I mean, that goes down to, I mean, not just sort of free from, not just like you're going to fall down the stairs, but things like damp come under that. So damp and mold are things that can make you sick. So they must ensure that the property is in, again, I suppose it goes down to the state of the condition of the property, the state of repair. But it's, yeah, damp and mold are slightly different from broken things. So if your property is in disrepair, then the landlord is responsible for sorting it out, fixing it. But the landlord will only be responsible for disrepair that they know about. So it's down to you to notify the landlord. And from my point of view, since we take landlords to court for disrepair, it's so much easier for us if you've written the landlord an email rather than made a phone call, because it's really difficult to prove that you've told the landlord unless you've got it in writing. Yeah, and then once the landlord does carry out repairs, they've got to do so within a reasonable time and to a reasonable standard. And then other responsibilities of letting agents or landlords are they must carry out an electrical safety report, a bit like the gas safety certificate. With that, they could be fined by the local authority if they don't. They've got to make sure that they follow the fire safety regulations, have in place smoke and carbon monoxide alarms, and then you probably know you're living in the property. So if the battery runs out of your alarm, it's down to you to replace it. And yeah, the landlord wouldn't know about it. And yeah, and oops, I've gone forward. And the local council can take enforcement action and fine the landlord in case of breaches. And then the sort of things you can do if the landlord or a letting agent isn't meeting his end of their end of the bargain, depending on what's gone wrong, you can complain about a landlord to the local authority, the local council. For example, you can report disrepair to the local council. If the landlord or the letting agent harass you trying to get rid of you without a court order or evict you unlawfully, you can report it to the council. The council can prosecute. For licensing breaches, so not having a license when a license is required, or even not complying with licensing requirements. So for example, for HMOs, has a multiple occupation, the landlord will need to put fire extinguishers in the property. If he doesn't, then you can report it to the council. Unfair trading practices, or you can complain to I think that's what Peter's going to deal with, complaining about letting agents. Yeah, I suppose there are redress schemes, trading standards, local council. I won't say too much. And then you can get out of a tenancy. I mean, if it's really unbearable, probably the landlord dislikes you as much as you dislike him or her or they. So you might be able to come to an agreement with the landlord to cut the contract short. You leave without further charges. They might agree, or if in the first 90 days of a tenancy, you can kind of rescind it. You can, under consumer protection law. And if you do it within the first 30 days of a tenancy, you can even get any money you paid back. So that's normally for misleading practices. So if the landlord's convinced you, or the letting agents has told you kind of lies, so you moved in and it's just not the way it was represented, that kind of thing. And then you can apply to the first year tribunal for rent repayment orders, for repayment of holding deposits, compensation for tenancy deposit breaches, or you can bring court proceedings, go to court, and that you go to court to force a landlord to carry out repairs, for example. While you're there, you might be able to get compensation for disrepair. Or if you have been illegally evicted or harassed, say the landlord's cutting off the electricity or kind of harassing you in other ways in the hope that you'll leave the property without the landlord having to go through the proper procedure, then again, you could go to court to stop the harassment or to get reinstated if you've been illegally evicted and to get compensation. And then we're there. I don't know if I've probably gone over. You can't be evicted without a court order. So if you come home one day and the landlord's changed the locks, then that's a criminal offence. So remember that, and then that's it. You can read them in your own time, what advice for renters do, and useful resources at the end.
Amazing. Thank you so much, Karen. Yeah, we'll be sending around the PowerPoints to everyone after tomorrow. So ample time for them to read back through and take it all in. Although that is really insightful. Thank you for that. Brilliant. So a few questions have come through, but we will save them to the end of the questions section. So some of them are really excellent. So please don't worry, we'll be addressing the questions. Next up, we have Peter from the Property Ombudsman to give his presentation.
Thank you, Tilly. Thank you, Karen, as well. Let me just share the screen. Hopefully it should all work. Can you see that?
Yes, we can, or I can at least.
Brilliant. Well, as long as everyone can see it, that's the main thing, isn't it? Thank you very much for inviting us on this evening. Just a little bit about me before I go into the presentation. I've been with the Ombudsman now for nearly 15 years. I started as an adjudicator, became an adjudicator manager, and since gone on to do obviously work in policy, hence I'm the Director of Policy now. What I'm going to talk to you about tonight is a number of things, mainly what the Property Ombudsman actually is, and try and get through a few misconceptions about the scheme. What redress schemes, ADR schemes and Ombudsman actually do, because it's not always quite the same. Who's actually required to join the scheme? I'm going to talk a little bit about our letting agent code of practice and what that means for the agents out there. And then I'm going to touch on some of the common issues which are presented to us by tenants. And then finish off by hopefully giving you a bit of advice of how to complain and how to complain well. And then finally, if needed and a complaint comes to us, how we go about dealing with it and how we're going to interact with you if a complaint does come to us. So looking at who we are first, the Property Ombudsman Scheme, we're actually many things. In fact, we're 4 different things. We're an ombudsman, we're a redress scheme, we're an ADR scheme, but we're also a code sponsor. It's all a bit confusing, but fundamentally, our job is simply to resolve complaints. And if we find there's a situation where an agent has not provided the right service, we will assess a complaint to see if there's some sort of financial award, some sort of compensation, or some sort of direction we can give to the agent to actually make things better. That's our role as a redress scheme. Our role as an ombudsman, I'll come on and talk a little bit about later. And what I'd like to probably focus on a little bit on this slide is our role as a code sponsor. And that is very much a separate thing from resolving complaints. But it's actually quite integral to us as an ombudsman, because actually the reason why we have a code is it helps from all the lessons that we learn through all our casework gets fed into our codes, which means they get updated with the right standards which are relevant and current, basically. And importantly, that code is also approved by trading standards. So it has to meet certain criteria. And as you'll see on the slide as well, as an ombudsman, as a redress scheme, as an ADR scheme, we have to be approved by various different bodies, including the Department for Levelling Up, National Trading Standards, the Ombudsman Association, and all of those approvals mean that every year we have 4 different audits, we have meetings throughout the year, and the point is to check that we're fit for purpose, we're independent, and we're doing our job properly. Going into what a redress and an ADR scheme does, it's pretty much what it does on the tin. It says on the tin, really. Fundamentally, the role is to provide redress to consumers by considering complaints which fall within its remit, by judging the dispute based on the evidence provided by both parties, and by reaching a decision, and if appropriate, making a financial award or a direction to put something right. However, what I need to say really is awards are about trying to put the consumer back into the position they would have been had the issue which caused the complaint not occurred. That essentially is the definition of redress. It's not about punishing agents. It's not about fining agents. Those are regulatory functions, and those are functions which are carried out by trading standards. So this is why when we get into talking about awards and all of that sort of stuff, it's to bear that in mind. We can't fine or punish them, but what we can do is provide compensation for when things gone wrong. Turning to who needs to join the scheme, I'll give you a very short, abbreviated history of how all of this has come about. Back in 2007, I think it was, the Consumer and Estate Agents Redress Act made it mandatory for all estate agents to become members of a redress scheme. But as we all know, many estate agents also carry out letting agency work. So it was really quite confusing for consumers going into an agent's office where one half of the office was covered by redress and the other half wasn't. So consequently, after many, many years of talking to government and all of these relevant people, the law, the Enterprise and Regulatory Reform Act came in 2014, and that made it mandatory for all letting agents and all managing agents in England to become members of a redress scheme. There are currently 2 approved redress schemes, of which we're one of them. We've been going for about 30 years now, have multiple codes of practice. There's also the Property Redress Scheme, who were formed in 2014, and they're part of the Hamilton Fraser Group, which you probably would have heard of some of their other things, such as My Deposits, Landlord Action. They have a number of insurance products as well. They also own the Landlord's own website as well. For ourselves, we don't really have any commercial interests like that because we're an ombudsman. And it's straightforward, really. We just resolve complaints. Both schemes also have a number of voluntary memberships. And importantly, certainly what you can see from that and what you can see from the bottom of the slide, the massive gap in redress right at this moment in time is landlords. And what we know is there's a Renters Reform Bill, which is currently making its way through Parliament. And it's something obviously we're very supportive of, because we don't want to see any gaps in redress out there. Everybody should have equal access to justice. So turning to our role as an ombudsman scheme is a little bit different than just being an ADR or a redress scheme. Being an ombudsman means actually we need to be approved to actually use the name ombudsman. We have to adhere to a separate criteria, and we get validated every 3 years to make sure we're actually doing it right. But the reason why an ombudsman is a bit different because it offers a number of additional services on top of just resolving complaints. So if I can talk a little bit about our front-end inquiries function. We have about 45 to 50,000 people contact us a year on our inquiries function. And the job of the inquiries team is to help people to try and resolve matters before they actually turn into complaints in the first place. And we do that by providing advice, by providing guidance, and all of those sorts of things. And what we do is we will talk whoever the consumer is, whether it's a tenant, a landlord, a buyer or seller, through their individual circumstances and try and help them work it out. What that function also gives us is a really good early warning signal if we're starting to see new emerging practices within the sector. And again, that helps us with intelligence, and it also helps us to identify potentially specific agents where we start finding multiple inquiries coming in about the same issue. So it's really, really good as an early warning system. So that's our inquiries function. The other thing that makes us a little bit different from redress and ADR schemes is we take what we call an inquisitive approach to resolving complaints. And what this is about is simply levelling the playing field between consumers and property businesses. Now, It's fair to say that not many consumers have a great level of education in terms of property, and they're certainly not property experts. So when it comes to complaining, it obviously puts them at somewhat of a disadvantage. The inquisitive approach we take, and indeed all ombudsmen will take, means we won't just judge a dispute based on the evidence which has been submitted from both parties. We will look at the evidence, and if we see there is gaps missing in the evidence, we will go back to the consumer and we'll actually ask them for this, or we'll go off and carry out our own research. The bottom line is we want to make sure it's balanced when we do this, and this inquisitive approach allows us that balance to make sure that nobody's going to be disadvantaged when they come through our process. Another important point here is standards. Now, as an ombudsman, we have a duty to feed back to the sector to try and help standards get better. And we do this through several ways. Obviously, our codes of practice are a really good demonstration of this because, as I said before, the learning from our casework, the learning from our inquiries go into those codes. So what we try and do is we try and help certainly all of the TPO members get better at what they actually do. What we also do with the data and the insight that we get, we feed that back to all of those approval bodies that you saw at the start, one of which includes the Department of Levelling Up. So they get this information, which helps very much with their policy thinking. And certainly some of the information, the data and insight we've provided over the years, you can see it now in the Renters Reform Bill and previously in the white paper, the sort of issues that we've seen. And probably the final thing to say about ombudsmen, which makes them a little bit different, is we're not-for-profit schemes. And what that means is essentially, if we do make any money through any of this, it gets reinvested back into the scheme. Doesn't get paid out to shareholders, doesn't get moved over to other businesses or anything like that. It gets reinvested in the scheme. And that's really, really important because it means we can do things like our front-end inquiry service, like our codes of practice, because at the end of the day, these don't make any money, but they're the right things to do because they help people. And so that's why being a not-for-profit scheme is really, really important. So that's a little bit about ombudsmen and why they're ever so slightly different to the redress and ADR schemes which are out there. Turning to our codes of practice, as a code sponsor, we produced our first lettings code of practice back in 2006 now. And since then, it's had numerous revisions, obviously, as I said, through the casework that we see, but also because of the changing legislation. And as Karen touched on earlier, the Tenant Fees Act was the last bit of major legislation in this area. And actually that made us do almost a complete rewrite of the code itself. So touching on tenancy payments, which Karen mentioned earlier, for example, if you were to go and look at our code and download it from our website, you will see there's a whole section on tenancy payments, and it will list all the payments which are allowed and all the payments which are not allowed on there. So actually it's a really good crib sheet, not only for agents to make sure that they're doing it right, but for consumers to check that their agents are doing it right. The other thing perhaps is important to mention is our approval means we can't actually impose this code of practice on all of our members. It's a quirk of the approvals, which is a bit problematic. However, 95% of all the letting agents which have signed up to us have agreed to follow the code of practice, which I think actually underlines the value that they actually see in it. And what you can do is you can always check if an agent is following it, because they should be displaying that pink logo that you can see next to the Property Ombudsman logo, whether it's on their website, whether it's on their high street branch or wherever. So that will give you some degree of comfort that they're following the codes. And of course, you know, what that also helps to do as well is if you download a copy of the code yourself, you can check that they're doing things right. For us as well, also owning the code and being a code sponsor means sometimes we're often confused as a regulator in this sector. We're not a regulator, but I think it's quite understandable why that misconception is there. I mean, for example, if you look at the social housing sector, if you look at the financial sector, for example, they have a regulator, but there is no regulator for the private housing sector. there is a regulator-shaped hole. And of course, when you hold a code of practice and you hold these standards, people assume that you will be able to take some form of regulatory action. We can't. That's for trading standards to do, basically. What it does mean is our codes are used by our adjudicators when a complaint comes in, and we will judge an agent's actions against those standards in the codes. The agents themselves use the codes to check that their business practices are indeed actual best practices. And of course, as I've mentioned earlier, consumers use our code to check that the agents are acting correctly. So if you've got any particular issue which in your tenancy, which you think the agent should be doing something about and they're not, it's always a good point to check the code first to see actually what they should be doing. And it gives you a really, really good reference point if you're going to communicate with them. So I'm now going to cover a few statistics, general statistics on our workload last year, and then I'm going to go into a bit more about the actual inquiries and the disputes we've seen from tenants and give you an idea of the sort of things we see and how we deal with them. So you can see a lot of big numbers on this slide, which is all great. But basically, to give you an idea of the organisation itself, we're actually quite a small organisation. We have just under 100 members of staff, and only about 50% of those actually deal with inquiries and resolve cases. And when you're looking at 45,000 people contacting us at the front end and 6,000 disputes, are being resolved a year, that's not actually that many people. What we've seen over the years is, alongside an increase in volume and demand for our service, we've also seen an increase in complexity in the complaints coming in, which is really interesting to look at. So, for example, in 2019, the average case we had from a tenant had 3 complaint issues in it. Last year, that rose to nearly 5 complaint issues per case, which means people are complaining more. They're complaining more about what's going on, and they feel more empowered to complain more, which is all good. But what it also means is that cases become more complex, and sometimes they take a little bit longer to resolve. So we've looked at this, and to meet this demand, we've obviously increased staff numbers over time. And while we have offices based in Salisbury, we've also transitioned into a completely remote organisation now, and we have staff throughout the UK. We're also looking at digital solutions to help people, because we're all starting to get more and more used to those. Obviously, for straightforward cases, they're really helpful, but at the end of the day, there's always complex complaints out there. And as an ombudsman, we have to be accessible to everybody. And this means, people should be able to contact us via non-digital means. And of course, that also helps as well when we can identify vulnerabilities, and that allows us to take special care and attention when people have those vulnerabilities. Perhaps the interesting point on this slide, certainly for me, is that 98% compliance rate with our decisions at the bottom. So to put this into perspective, we have nearly 40,000 members, which attracted just over 6,000 complaints last year. And of those agents, only 22 agents failed to pay the award. Of those 22 agents, all of them were expelled from the scheme. We have an agreement with the other redress scheme that when an agent hasn't paid an award, they can't then go and join them, meaning they either pay the award or they're trading illegally. And if they're trading illegally, then they are subject to enforcement action by trading standards and could potentially face a fine of £5,000. So that gives you some comfort in the fact that when you come to us and the awards are made, they are going to be paid. It's as simple as that, really. Turning now to more tenant inquiries, and I'll cover the tenant disputes in the next slide. Unsurprisingly, what we saw, it certainly last year, was issues being presented to us at the inquiry stage mainly concerned repair and maintenance issues. These were the main reasons why people were seeking our help. Now, obviously, while a lot of these could be resolved by landlords putting their hands in their pockets, what we were able to do is provide tenants with advice to help them understand actually who is responsible for what in the tenancy, who is responsible for the heating system, who's responsible for the washing machine, who's responsible, so on and so forth, which is really, really important. And what is absolutely crystal clear from all these inquiries we get from tenants is that actually consumer education is a key piece of work that needs to be addressed here. the more people know about their own rights and responsibilities, and what an agent's rights and responsibilities are, and what a landlord's responsibilities are, the clearer and easier it is to resolve things when things go wrong. The other interesting statistic throughout here is where an agent's not actually involved. And what we saw when tenants were contacting us where there was no agent involved is that repair and maintenance issues increased. And again, I think that again underlined the need for consumer education, and I mean that for both tenants and for landlords in the sphere. So that was the inquiries function. Turning to the actual complaints we investigated. Interestingly, while you saw on the other slide that 61% of all our lettings inquiries came from tenants, only 45% of those actually translated into cases that came through our system. Why? Well, I'll go back to the consumer education point, insofar as actually most tenants were contacting us simply for advice and guidance on a specific issue. It wasn't actually a complaint, or it could have been a complaint, but that advice and guidance stopped it being a complaint. For those cases we did investigate, you'll notice that 69% of them were actually supported. Now, this is actually quite a high figure. But what it takes into account is the impact of that previous inquiry service. In other words, if we weren't an ombudsman and didn't provide that inquiry service, we would simply accept the complaint and then not support it, which would be a waste of everybody's time, quite frankly. The other important point to make here is the average award. You'll certainly see on our website that the ombudsman can award up to a maximum of £25,000. But that really rarely happens because, as I go back to what I said earlier, redress is not about punishment. It's about putting people back into the position they would have been in had the incident leading to the complaint not occurred. And in most cases, the awards made are for aggravation and for inconvenience and occasionally for financial loss. So hence why we have an average award of about £500 for letting cases. Finally, in terms of issues, again, repair and maintenance issues was the area of most concern for tenants, but worryingly, the manner in which agents handled their complaint was the second highest issue. Now, as an adjudicator, we've seen many complaints down the years. There's no excuse for poor complaint handling. There really isn't. The procedure for handling a complaint properly is in our codes. It's in consumer guidance on our website. It's in agent guidance on our website. It's also in the membership deed, which they sign up to. So invariably, where we see poor complaint handling, agents are much more likely to attract an award against them when we see it. So turning to actual complaining itself, hopefully things don't go wrong for you and everything's absolutely fine. But when things do go wrong, it's about knowing what to do and where to go about it. So what this slide shows you is the blue bits are essentially what you need to do, and the yellow bits are essentially what the agent will do. To reiterate, this procedure is set out in our codes. It's also in our consumer guide on the website, and it's certainly a requirement of all TPO agents that they have an internal complaints procedure. What I would say is, as you look through that, as an adjudicator, I've seen many complaints down the years, and it's probably a good time for me to share just a few insights. So if you are in the position where you do have to complain, you can do it in a way which is hopefully going to get matters resolved a lot quicker. So 3 points for you to take away from this. Firstly, less is more. And I mean that in the sense that big, long complaints don't always have the desired impact that you want. Often, and I'm guilty of this myself, people let problems build up and all of a sudden there's a big, long list of things. Having a big, long list of things makes things more complex and harder to resolve. It also means disputes can become more protracted, and as they become more protracted, they get more emotive as time goes on. So the first tip really I would share with you all is, if you have a problem, raise it with the agent immediately. Don't wait. Communication at the earliest point in this gives the agent a chance to fix things there and then. The second point I would make, and I go back to what Karen said earlier, is written records. Wherever possible, communicate with agents in writing. Phone calls happen, and that's part and parcel of it, and that's absolutely fine. But if you have a telephone conversation, it's really, really important to make a note afterwards of what was discussed, and importantly, what the agent agreed to do. And if you want, you can put that in an email to the agent, send it to them, and that gives you a chance, and certainly them a chance, to correct anything that might have been misheard, or indeed, if they don't come back, you can take it as read that that was what was agreed. Importantly, if you have to escalate your complaint to the Ombudsman, those notes will become crucial evidence, and they will allow the adjudicator to compare those notes with the agent's notes, and that will help to get a good decision. So, written records, much as you can write down, the better. And finally, the last point I would make when complaining is please, please, please be polite. No matter how angry you feel, and we all get very angry at times, just try and be as polite and as reasonable as you can. It's not easy, especially if you felt you've been treated badly, and especially if issues have been going on for a long time. But try and remember, and I know it's hard sometimes, but try and remember that agents are humans too. We're all humans, and nobody will feel inclined to help you if they feel like they're personally under attack. Be polite, be reasonable, and you're more likely to get what you want. Finally, if unfortunately the complaint has to be referred to us, what can you expect? Well, firstly, the first thing that we will need you to do is to complete a complaints form. But before you get to us, actually, I've missed this bit out. Before you get to us, the agent should have written to you with their final viewpoint letter. And in that letter, they should have told you that you have the right to refer it to us and the timescales to refer it to us in. And that is essentially 12 months from the date of their letter. At that point, you can come onto our website, and we have a button called Make a Complaint. That will take you through a series of questions. There's only about 5 or 6 on there, which will then get you to the complaint form. If you can't get to complaint form because it falls outside of our jurisdiction, the website will actually give you some advice and signposting about where you can go if we can't help. So please, please do use that. What the website will also give you is a phone number if you want to ring and talk to someone through about it. So that's really, really important. But importantly, for us to start our procedures, we need a completed complaints form. Once we've got that, then we can start the ball rolling. And what we will do when we've got that complaint form is we will assess it for the best way we think it is to resolve the complaint. And we will consider a number of methods, but predominantly we've got 2 methods of complaint resolution. We got what we call facilitated early resolution. So we use this for perhaps the most straightforward cases. And what we will do as part of this process is a form of mediation. We will talk to you, we will talk to the agent, we might talk to you together. But the point is to try and bring all the parties to a point where there's a mutually agreeable resolution. And as I say, this method lends itself to more straightforward cases that can be resolved reasonably quickly. However, we do have the option of conducting a formal investigation. And as I touched on earlier, we get some quite complex complaints in. And this may involve an adjudicator contacting you to ask for more information to what you've submitted, and so on and so forth. And obviously that takes a bit longer, but it ensures that actually all the issues get a thorough examination. And as I say, and hopefully at the end of all of that, you will get a balanced outcome. And finally, it's really, really important to note that for both of those processes, consumers have the right to either accept or reject our decision. Now, if you accept our decision, it is binding on the agent. They have to pay that. Otherwise, they go down the route of being expelled, so on and so forth, like I talked about earlier. But what you can also do is if you don't like the decision, you can simply reject it. And if you reject it, you are free to take that dispute to the courts or wherever else you want to go. So the power is with you throughout. It's an optional service. You don't have to use it. But you will see certainly from those numbers in the awards that we've done, it's a very effective service. And as I say, it's been going for 30 years and it's getting bigger every single year. And I think that's it in a nutshell, Tilly. I'll stop there.
Amazing. Thank you so much, Peter. Again, we will be sharing Peter's PowerPoint around with everyone. So that will give you time to take it all in your own time. Yes, no, brilliant. So I'm a bit conscious that we're quite a little short for time. So I'll try and whiz through the questions as quickly as possible. So the first question is about reasonable adaptations in privately rented accommodation for disabled or impaired tenants, and sort of roles and responsibilities that landlords have towards that. I imagine that's more a question for Karen and or Mark as to what responsibilities landlords have to adapt their properties for disabled tenants.
Mark, do you want to answer?
It's not something I normally cover, I'm afraid, so I don't want to say anything that might be incorrect.
Yeah, basically, as far as I know,
Section 21 notice validity, I don't know if you'd be able to answer. I don't deal with the Section 21 notices myself.
Mark is an expert in the tenancy deposit dispute and rent repayment orders, which to me are really obscure. But no, sadly, they don't have to do much. As a private landlord, yeah, I've had people go to their landlords with a letter from the council saying, we're paying for these adaptations, you don't have to do anything. And if the landlord doesn't agree, then there's no forcing a landlord to make any adaptations. I mean, even, you know, if you're disabled, you can't get into your own bathtub, you need a walk-in shower, they can refuse. And then, yeah, I guess you have to move. I had one recently where the landlord agreed to do the adaptation. It was a handrail up, or one on each side up the stairs for the person. And but they pointed out that when the person moves out, then it's in their contract, they have to reinstate the property as it was before, so at their own expense. So I mean, what will it might, there'll be a few holes on along the walls up the stairs that the tenant would have to pay for filling and painting and things like that. I don't know, it could be a few £100, I suppose. But yeah, there's no way of making them do it.
As Karen's mentioned before, Shelter England website on housing law may have more on both those issues. Shelter England is a really good source of housing information and legal advice.
They are brilliant. So a second question is contact details of landlord legally requested by tenants, but they're refusing by refused by the letting agents. How does this impact the validity of a Section 21 notice?
Bad again. It doesn't. Yeah, as far as I know, yeah, the landlord has to provide an address for service of notices, but it doesn't have to be their address. It could be the letting agents or a PO box or whatever. However, the tenant is entitled to have the landlord's address, real address. But you can still, like we were saying earlier, if the landlord doesn't give a valid gas safety certificate, then a court won't evict under Section 21 notice, for example. But I don't know of any penalties other than, I think, the council or whoever can. It is an offence under the Housing Act, no, the Landlord and Tenant Act. But I think you can be fined a little bit, not even a lot. In fact, I think that it's the fine at that point would probably, or the breach would probably be by the letting agent, assuming that you're asking the letting agent, you know, I want my landlord's contact details. So I suppose you could complain about the letting agent for not giving them.
Is that something that would come under the Ombudsman, Peter?
Yeah, we could certainly look at that. That's not an issue, but I don't think it's going to get you the outcome that you're looking for there, because obviously we're talking about that in relation to Section 21 notice, and if it's not going to stop that, then well, we could look at it and we could support it, and you might get a small award of compensation. It's probably not the outcome that I suspect the person asking the question is looking for.
Another question has come through. It says, with respect to tenancy documents, I think Karen did touch on this after the question was asked, so you may have already answered this, but they said, what about electrical safety certificates instead of gas safety if the property doesn't have a gas supply?
Yeah, all properties have to have one. They're valid 5 years. But again, if Whereas if as a landlord, if you don't give the energy performance certificate, the gas safety certificate, or the house rent book, or you commit tenancy deposit breaches, then you can't use a Section 21 notice. If you don't provide an electric inspection condition report, no, electric something
installation condition
report. If you don't provide one, again, you can get fined, but they won't. I don't know why they haven't sort of integrated it with the Section 21 rules.
On the sorry, Tilly, I've got some helpful stuff on that. The electrical installation condition report. There's two sources for tenants that are really useful. There's a charity called Electrical Safety First, and they do a guidance for tenants. And there's also a government document, a guide for landlords, but it's also for tenants, on electrical safety standards in the private rented sector. They're both really good documents on the EICR, the Electrical Installation Condition Report. And they should be done every 5 years.
It's written them down, so I'll make sure to include those in the email that goes around as well.
Thanks.
So another really good question come through. So they've said, should documents, in brackets energy certificates, be given prior to application/deposit or not required? And how do you determine if they are the latest ones, in brackets, have an expiry date?
Yeah, they all have a date on them. So the energy performance certificate will tell you the date it expires. That's valid 10 years. The EICR, the electrical one, is 5 years. The gas safety one is an annual one. The how to rent booklet, it says somewhere, normally I think it's on the second page, March 2023 or October 2023, one just came out. So you'll know which one. But again, sorry, what was the question? Because with there was something I was going to say, and now I've forgotten what the point was.
It says, should documents be given prior to application?
Right, that was it. Well, in theory, you're supposed to get them even before you enter the tenancy. Presumably, you want to know what the energy efficiency of that property is before you sign that tenancy agreement. But as another question touches on about the landlord who didn't protect the tenancy deposit till they wanted to bring the Section 21 notice, all these breaches, you as a landlord, you've never given a gas safety certificate, you want to evict via a Section 21 notice. So you send the tenant in the same email the gas safety certificate for this year, they've been in the property 10 years, and the Section 21 notice, and you can use the Section 21 notice as a landlord. So they are good rules, but they are ways of kind of landlords that can wiggle out of them as well sometimes.
Mm-hmm. I think, yeah, just you're touching on a secondary question, another question someone asked, which is that they only provided the deposit several years later after the conversation. Does this still protect me from a valid Section 21? That's
certainly one Mark can answer, because there is more to it than just a Section 21.
I think the question says, can they claim compensation still if the agent protects a deposit several years late? The answer is yes, they may be able to. The normal time limit is 6 years from the date of breach by the landlord. So if you think about it, that's 6 years and 29 days from the date the deposit is paid, because the landlord's got 30 days to comply with the deposit regulations. So I don't know when this tenant pay the deposit. If it's within 6 years, they should be able to claim. But if there've been tenancy agreements since the first tenancy when the deposit was paid, you may still be able to claim, because the landlord has to comply with the deposit regulations if there's a new tenancy agreement, or if there's what's called a statutory periodic tenancy at the end of a fixed term tenancy. Sorry to get a bit technical. So it's quite possible that several years after you initially paid the deposit, you may have a claim, a compensation claim against the landlord. It's under Section 214 Housing Act 2004. But you do need to get legal advice if it's more than 6 years, because it's a bit more complicated. It's certainly possible if you've had tenancy agreements since the first tenancy agreement. And also it may be possible under a very technical Limitation Act 1980 argument, if there's sort of been misrepresentation by the landlord in some way. But again, that's very technical. So get legal advice if you're getting near the 6-year time limit, to see if you can still make a compensation claim. It's actually called a penalty claim, and it's between 1 times and 3 times the deposit.
Very interesting. I didn't know that actually. So that's at least I've learned. Many people learn things I know, but me in particular.
It is all a bit, get legal advice. It is all a bit technical.
Yeah. Someone has asked a question here. They've said, if litigation is struck off by the tenant, by the TPO after a client reports a problem, how can the director of the company at the time the incident occurred step down as director just before financial decision on the case is made, and then set up another company? They use the original company's trading name and its employees and continue with the same bad practices. This happened with the litigation managing property I live in. I think that's sort of referring to a litigation has been struck off, and then they've just created a new company and are carrying on doing what they were doing before without sort of being reprieved. Is there anything on that?
Yeah, I mean, this is an issue we've been speaking to government about for many, many years. And it's not just happens in the property sector, it happens in every sector. The businesses fold and then they phoenix again, which is the term which is used for it, is phoenixing again, and the new company basically gets set up. What we do, and I certainly what the PRS do, we try and do the checks on the directors and all of that. But there are ways that unscrupulous agents, and indeed any business in any sector, can get past all of this. It's something we've been talking to the Department of Business about for many, 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 many years. That's all I can say. It's in government's hands.
Thank you, Peter. It's just, we're at time now, but there are just a couple more questions, so hopefully we'll be able to whistle them relatively quickly. So someone has asked, they said, why do we have several different ombudsman services, i.e. the property ombudsman, the housing ombudsman, which is currently for social housing with some private landlords, voluntary signing up to, and the new proposed private rented sector ombudsman, and how will the latter be resourced?
So the question in 2 parts. Why do we have so many different ombudsmen? Why do we have so many different redress schemes? Why do we have so many different ADR schemes, as I covered? It's simply because of a patchwork of legislation which is out there. It's as simple as that. If you look in various different sectors, it will have different types of legislation. Some will say ombudsman, some will say redress, some will only cover certain parts of the market. And as I touched on earlier, there's still big redress gaps in the private housing sector. There's no 2 ways about that. And, alongside landlords, for example, developers who built new homes, it's still not mandatory for them to be members of an ombudsman scheme, and so on and so forth. Why is there so many of them? Because the sectors are so large. It's as simple as that. But as time goes on, there'll be less and less of them, I think, because at the end of the day, I suspect everybody would like one single ombudsman for all public services and one single ombudsman for all private services. It seems like a very sensible way forward. In terms of the second part, the question's gone now from my screen. What was the second part of the question?
Sorry, that's my fault. Okay. I keep clearing them away to keep on track of it. They said, how will it be financed?
How will it be resourced?
Resource, sorry.
Yeah, resource. Well, this is a really good question, which government, I know, are currently considering. It's going to be a very, very big undertaking. I think there's over 2.5 million landlords out there. How do you capture 2.5 million landlords on a database? How do you ensure that all of them are signed up? How do you do all of those? So there has to be some real technological solutions to this, including databases and all of that. In terms of the actual resourcing to run an ombudsman scheme, it's going to be a mixture of obviously humans, but also, you know, digital processes, because it's got to be able to deal with volume, but it's also got to be able to deal with complexity. And you need humans to deal with complexity. AI is not that clever yet. And it probably never will be, because we're humans and we do strange things sometimes. We have strange behaviors which cause strange complaints sometimes. So it will be a challenge, but it's not something that's insurmountable, and it's something which is desperately needed, certainly in my view.
The person who asked the question about the phoenixing has sent on some extra information, which I'll have a read of later. It is the sort of issue with letting agents is on generation rents, but we are aware of it as an issue, and it's something that we'll be interested in finding out more about. So if you want to drop me a line or contact us directly then about this as an issue, then we'd be happy to learn more about it directly from you if you're interested in doing that. So final question. Someone has asked, some landlords letting agents use third-party services to log repair requests, track progress and mark complete. If the complete items are removed and no longer accessible to the tenant, does the landlord have to give copies, or is it on the tenant to make copies, screenshots of their contact?
So on the software, there's lots of different repair and maintenance software out there. From certainly the ones I've seen, they should have the ability to actually provide a report, and they provide a report for the agent. They certainly provide a report for the tenant. If a complaint comes to us and we know that that software is being used, we will ask for the report from that software. It's as simple as that. If it doesn't, then yes, best advice I can give is screenshot it, quite frankly, because it's all about written records.
So thank you, Peter. Right, that's all the questions. I don't know if there's anything further from speakers that they feel is any resources or points that are outstanding that you'd like people to know. Now is the moment to go for it. I think we're good. Okay, so I'll just share a very final screen for a send-off. So thank you everyone for listening in. I hope it was very useful. It was useful for me. I've learned some new things, and I've been doing this for 3 years now. So there you go. If you are interested in getting involved more with us as an organisation, there are 5 main ways that you can help. You can stay in touch with us by signing up to our mailing list on our website at generationrent.org/sign up. If you have any stories and experiences that you'd like to share with us in order to support our work, then you can go to generationrent.org/share your story. If you want to get involved in our research panel, if you are a private renter, which I presume almost all of you will be here, you can get involved in our renters panel, which is our research-based panel where we hear directly from private renters in order to inform our work. If you're interested in supporting us as campaigners, as volunteers, and you can be a private renter or you cannot be, then head to generationrent.org/volunteer. Find out more you can do for us there. And finally, we have an ongoing prize draw at the moment, and you have a chance to win a book. There are several different books up for grabs, all very, very interesting about renting and housing. So to go there, go to www.crowdfunder.co.uk/p/help us fight for renters, and we will be sharing all these links around tomorrow, along with the PowerPoints and the links mentioned here. So yes, that's it. A few minutes over, so I do apologise, but we did get all the questions, and I hope that was useful. And at that, I will leave you all for a good evening, and thank you all for joining us. And thank you very much to Karen, Peter, and Mark for
having me.
Such spectacular